Welcome to Looking at Legal Stuff. Today we have 12 hearings with a high conflict couple where dad is trying to get a default order entered for the parenting plan, and he also thinks mom should be held in contempt for not paying support, and that's just for starters. Dad has one accusation after another and fights mom every step of the way while she tries to reestablish visitation. But what does mom have to say for herself? Let's watch.
Cameron Miller and Taylor Young. I see a Taylor and I see Mr. Miller. All right, good morning.
Good morning.
Ms. Taylor, were you asking for a continuance earlier?
Yes, I didn't receive.
Ms. Young, I guess. I'm sorry.
Yes, I haven't received like the paperwork itself, and so I don't know exactly what I'm going against. And I also would like to get an attorney because this has been going on for far too long. And my dad just passed away, and so I've been dealing with that this week, and I did not have time because I just got the little piece of paper in my mail the day before yesterday. And so I got to go to USPS and get the paperwork, I guess. All I got was the thing, but I didn't know that until I checked my mail.
Mr. Miller?
Can you hear me, Your Honor?
I can, yes.
Okay, so I want to put it on record that Miss Young's packet actually was delivered on February 25th at her mother's house. Her grandfather signed for it. And we're here because she hasn't been paying child support, and she wanted to take it upon herself and to collect the taxes on a child that she has not been providing for over a year. So
and Your Honor,
I'm not finished.
We're not going to talk at the same time. Mr. Miller's turn. Go ahead, Mr. Miller.
In that I called all the right people, meaning like the IRS and all that, and they're doing an investigation on it because now it's tax fraud, because I have full custody of the daughter. Okay. I have full custody of her. The daughter lives with me. She goes, if you got something to say, Taylor, let's say it, because I'm not done.
So I can speak.
Just a minute. We're not going to talk to each other. Okay. You direct everything to me. And the question right now is whether I should put this over a week or two.
I would ask not to, because she has been properly served.
No, I haven't. I don't my mother.
Just
oh my gosh.
Let Mr. Miller finish, okay? And Ms. Young, if you speak out of turn again, I'm going to mute you. Okay.
She does. I have the paperwork of her grandfather signing for it. I turned that into the courts and all of that.
Okay, let me tell you. I'm going to accept it was served on February 25th. That still is not enough time for someone to respond. That's, I think, only 5 days, and that isn't enough for someone to respond. So based on that, on just that alone, I think a continuance is warranted. And you're bringing a motion for contempt. Really, nothing's going to change between now and a week from now or 2 weeks from now. So, Ms. Young, how long do you want to put this out?
I have a meeting with the cremator on Monday, but I'm meeting with an attorney next week. Okay. I talked to them already, and they're going to represent me because we've been doing this too long. And
okay, let's then go out 2 weeks to March 16th.
Okay.
And this is usually Commissioner Cotterell's docket, but if I happen to be on this docket in 2 weeks, I will expect everybody to be ready to go forward at that time. Okay.
Thank you so much.
All right. Thank you, Mr. Miller.
Thank you, Your Honor. Have a good day.
Yep. Next is Cameron Miller and Taylor Young. I see Mr. Miller's here.
I'm here, Your Honor.
Diane Lefker, limited license legal technician with Ms. Young, Your Honor.
Okay, thank you. I need to bring up two things. First of all, Mr. Miller had submitted a motion for default in this case that I've got several days ago. He did that ex parte. I didn't sign it because Ms. Young has been participating in the case. And when she appears, she, first of all, is entitled to notice of that. But I think her failure to file a formal response is at this point an oversight. She clearly wants to be involved in this case. So I'm going to set this out to March 30th, not the whole case today, but just the default portion of it. I'm going to set out to March 30th for Ms. Young to file a response. And if one is not filed by then I may enter a default, but I'm not going to do that today.
Yes, Your Honor, we'll get one filed right away.
Okay. What we're here about today is a motion for contempt that Mr. Miller has brought. And so, Mr. Miller, I'm going to ask you to argue that case first. You'll be the first one, and then Ms. Young, you'll have a chance to respond. And then Mr. Miller, you'll have a chance to respond to Ms. Young, and then I'll make a decision on that. Okay. So tell me why you feel a motion or an order of contempt should be.
Because Ms. Young has obligations to her daughter and she's not fulfilling them at all. She's had multiple opportunities to reach out to help with everything, and she hasn't done that. Taylor's about Taylor. Taylor doesn't care about her daughter or fulfilling needs for her daughter or trying to help her daughter. Taylor doesn't even have a job, for one, so she really can't support herself or her daughter. And, you know, I've been supporting Malaya now for over 2.5 years, okay? And she's been living with me. And I also want to put on the record that that packet that Miss Young turned in, completely false. For one, she doesn't state, and the sad thing is that she has an attorney that's helping her. The attorney can't be that smart because she doesn't ask the simple questions of the facts of, oh, me and Miss Young were together. No, me and Miss Young haven't been together for over 7 years. For all you know, Your Honor, you know, we just got done last week in a relationship. False, okay? The other thing is with child support contacting her, Miss Young says that they haven't. False. I just got a letter in the mail yesterday stating that they're asking me how to get a hold of Miss Young. How do we find Miss Young? Because Taylor does not respond. Miss Young does not go in to the post office and collects her packets that, you know, I turn into the courts. I send to her mother's house. I send to Miss Young's house. I have officers try to serve Miss Young. Taylor does not care. And quite frankly, I'm done. If she wants to go play around with some lawyers, well, I'll go get a big time lawyer too, and it will be done. Because I'm not about it for me no more. It was never about me. Like, Taylor is about her. This is about my daughter and what my daughter needs and what my daughter deserves. My daughter doesn't deserve somebody who does not care about her well-being or care about her needs or cares about her financial areas or where she's living or what, you know. I'm done. I'm ready to get it done and move on. That's all I got to say.
What are you asking the court to do?
Hold her in contempt because she has not done what she is supposed to be doing.
And what I understand from your motion, you've indicated she hasn't provided school clothes. Is that right?
Correct.
All right. She quit her job.
Correct.
She did not follow the parenting plan by administering the medication.
Correct.
Okay. You indicated on 6 occasions that you've determined she did not give the medication to Malaya.
Malaya.
Correct. Okay. Okay. Thank you. Ms. Young, would you like to respond?
Yes. Actually, Your Honor, I do have a job. When he went for child support, I was a jack in the box and I got a new job. He just didn't know that. I am fully employed. I have lived in my apartment for a year now, and I do take care of Malaya. The problem is I'd send her with clothes and stuff and they wouldn't be returned. So I would constantly be buying her new stuff. I asked for them to return her stuff and they refused to. So I stopped sending her home with clothes because they weren't being gave back to me. And so I said, okay, then when she's with you, you have her clothes. When she's with me, I have her clothes. I've never kept anything from her. I've never not taken care of her. Cameron keeps her from me. All these things he's saying he's doing. I want to be in my daughter's life 100%. He refuses to let me. And he hasn't always provided the medication. I have text messages of us trying to get her meds and he refused to give them to me. I already didn't feel comfortable with him. So we went for my grandfather, my mother, my uncle. We were all willing to get the medication and he refused. And then they just didn't respond. Then there's also much where Samantha said that it's okay for her to not have them for 2 days. She'll be fine over the weekend when they forgot the meds. So now I'm under the impression, so it's okay for them to forget meds. But when I did not give them to her one time because she was having a mental breakdown. And I told him that. I was like, she told me that they forced them down her throat. I wasn't going to do that. So I didn't give them to her that morning. Correct. But other than that, I do give them to her. We talked to my stepmom on the phone. She helps us. She hates them, but she definitely takes her medication. It's true I don't agree with it, but she does take her medication. And he hasn't had her the last 2.5 years.
Are you willing to follow doctor's orders on the medication?
Yes.
Okay. Mr. Miller, any response to?
Yeah. Oh, yeah, I got a response. Okay, so that medicine that she's just now talking about, where they tried to contact us to meet up with us, she's lying, okay, under oath again, because when I originally put all of this paperwork in, that's when Taylor kept my daughter from me for 3 weeks. 3 weeks. That's at the beginning of all of this, Your Honor. That's in black and white paper. Because that's where the restraining order came into play. That's how I got the restraining order on Taylor and with Malaya because of child neglect. Okay. That's how that happened. And I don't keep my daughter from Miss Young. When we first broke up in 2016 or 15, when Malaya was 3, Taylor was the first one to play that keep away game. I don't play the keep away game. Okay. And Malaya has lived with me for 2.5 to 3 years. I've already been in Cowlitz County for 2 years. I've lived with Malaya at my girlfriend's house, at her father's house in Napavine, Lewis County for a year with my daughter. That's 3 years running, going on 3.5 now. Okay. Malaya has gone to school down in Cowlitz County for 2 years. My timelines are adding up. Miss Young is completely wrong. Okay. Her attorney is not asking her the right questions. It doesn't seem like. The other thing is, what else was it? What else did she say?
Does Miss Young see Malaya now?
Every other weekend, because you guys, as your courts, ordered that. There was the other judge, the other male judge who was doing our case. That's why he offered every other weekend, is because he felt as though Taylor was putting Malaya in harm's way. He granted my no contact order. He granted everything because I came with the right documents. I'm doing what I'm supposed to be doing. And quite frankly, on docket, I'm not lying. Miss Young under oath is lying to the judge and to her lawyer. Flat out about it. And Miss Young knows she's lying. That's the sad part. Because if I was lying, I wouldn't have a solid case. I wouldn't have a solid case at all. And I'm pretty confident that my case is solid.
Okay. The other judicial officer was Commissioner Cotterell, who
yes, Your Honor.
those orders. All right, I've looked at the file and at the motion. Mr. Miller has brought a contempt motion indicating that Ms. Young has not provided school clothes, that when she was—
That's what it was.
To support Malaya, she quit her job. She hasn't followed the parenting plan, and a particular concern is that she has not given the ADHD medication. And as she indicated here, she doesn't agree with that, but she disputes whether the indication that she did not give it. I'm going to deny the motion at this point, and the reason is I did not see a child support order in the case, that there's no specific order relating to medication. She's given, I think, joint authority over healthcare issues, but to read that to mean that she absolutely has to give certain medications, I think that would be overly broad at this point. There's no tax exemption order, and there's nothing in the temporary restraining order about contact through third parties, which was another issue. So the reason I'm denying it is I don't think there's any orders that require what Mr. Miller says should have been happening. I do think Mr. Miller's order does raise issues that should be clarified going forward, okay? So I'm going to do that so that everybody is on the same page at this point. So first of all, if a physician has ordered medication, whether it be ADHD or any medication, then Malaya is to be given that medication, whether she's with the father or the mother, okay? And if from this point on, there's evidence that Ms. Young is not providing that medication, then that would subject her to a contempt order, okay? I'm gonna allow, this was not clear, but I'm gonna allow contact through third parties between the parties. I think a lot of times I will indicate that a protection order or restraining order prevents somebody from contacting the other party directly or indirectly. So that would include third parties. But here there needs to be some way to communicate regarding the transfer of the child and other issues. So I'm going to allow contact through third party. And finally, there were issues, comments made about disparaging remarks made to the child regarding the other parent. I'm going to prohibit that being done in front of the child. That the parties, the parents cannot, you know, for lack of a better term, badmouth each other in front of the child going forward, okay? So those are the three things I'm going to put in place today. I'll do a bench order to that effect.
Commissioner, can I add one thing, please? Can you, with the medication that's a controlled substance, such as the ADHD medication, that father is required to
I'm not
provide that
required to give you guys that
medication.
information. No, I am not.
Let her finish. Okay, Ms. Lepke, go ahead.
Thank you. That he is required to provide that medication for mother's visits, and if he doesn't, then he needs to make arrangements to get it to her in order for her to give the medication.
Okay, so I do send my daughter with medication. You should probably ask your person right there that when that was, when she decided to take my daughter out of her home 3 weeks prior to school. You must not be that good of an attorney.
Okay, so
I need to go. I need to go, please.
I'm going to add that if you expect, if the doctor has ordered medication and it needs to be administered during Ms. Young's visitation, that will be provided to her.
It is provided with my daughter to Malaya every other week, and my daughter goes there.
I'm not deciding that or even disputing that. I'm just saying that's going to be part of the requirement going forward.
Okay, and I want to put on record that I am not required to give the name of the medication to her mother. I'm not required to do that, and I'm not required to let Taylor go to Malaya's doctor's appointments. I'm not required.
I don't know if that's true. What I believe I saw
the restraining order. How is she supposed to go with the restraining order? That don't work.
Well, that may prevent it, but I think the parenting plan does not prevent that.
No, you're right.
Okay. All right, so I'm going to enter these orders as we've discussed.
I got one more question.
Go ahead.
Where's her attorney practice at?
Her attorney is what's called a limited license officer who, you can look it up. Ms. Lepke, do you want to disclose where you practice?
I have. He's already received my documents, but I practice with the law firm of Andrews, Terry, and Jeffers in Vancouver. And I'm happy to send you over
I already got it.
Okay, thank you.
Okay. All right, I think that's it for today. Thank you, everyone.
Thank you, Your Honor.
All right, let's call the Cameron Miller and Taylor Young matter. This is cause number 22-3-36908. See, Cameron Miller's on the line. Can you hear me, Mr. Miller?
Yes, Your Honor.
Okay, great. I can see you. And then I'll ask if Taylor Young is on the line. Taylor Young, are you on the line today? All right, Ms. Young, I'm not hearing you. If you are on the line, please unmute and state your name, please. Taylor Young. Okay, so I'm not hearing any response from Ms. Young. So it looks like, Mr. Miller, you filed, looks like several motions. One is a motion for a default. Second is a motion to amend a parenting plan. Third is a motion to amend a restraining order. And one thing I need to double check is the service. You've heard me talk a lot this morning about service. So let me just take a quick look at the file, make sure we're good there. Okay.
Hey, I'm almost done. We're on me right now.
Okay, so it looks like your motion, Mr. Miller, I'm seeing your motion for default was entered. Looks like you filed it back in September of 2022. Does that sound about right?
Correct.
Okay, and we had a hearing in September. There was some concern about service issues. Okay, I've got my notes here, so let me take a quick look at this. So looks like Ms. Young was served that motion for default, or she was served on the 26th of August of last year and also served on September 6th. Judge Basher found that 90 days had not transpired because it was serviced by mail. So at that time, Judge Basher denied the default order. because it needed to be a longer period of time. Then on September 22nd, both Mr. Miller and Ms. Young were present, and the judge entered a parenting plan at that time. And the mother has not filed a formative response or a formal response. And it looks like it was previously denied. And so we're back on. So was there so what I'm seeing, Mr. Miller, and I apologize for kind of talking out loud, is that there was that September motion for default that you filed. It was heard by Judge Basher. He denied it because the service time periods are longer when it's mailed, and the 90 days had not yet transpired. So he denied the motion for default. And so is there a new motion for default that's on the table?
I believe so.
Okay, great. So the clerk just looked at me and gave me that look and said, look in your paperwork. So I'm looking in my paperwork now. So thanks for your patience, Mr. Miller. I do see it here, so let me take a look at this. All right, so here's the new motion for default. I've got it. Thank you. So I did look at this earlier, so let me review it again. All right, there we go. All right, so the motion for default basically indicates that you're making a motion to the court because you filed and served the other party on September 22nd with a summons and a petition. And that was at least 91 days ago, kind of what we were talking about.
Right.
And that you live here and she lives in Thurston County and the kids live here, or child lives here, and that she's not covered by the Service Members Civil Relief Act. Okay. And then did you give her a copy of, did you give her a copy or send her a copy of this motion for default?
Yeah, I believe we did it through email.
Through email? Okay.
Yeah.
All right. Let's take a look here. Mailing, okay. Bear with me one quick second.
Yep.
Let me ask you a quick question, Mr. Miller. It looks like you filed a notice of a hearing for April 13th, this coming in a couple of weeks. What's the purpose of that? Is that the motion to modify the parenting plan or amend the restraining order?
I believe so.
Okay. So
a lot of this is just happening so fast, and I'm trying to juggle this and juggle work all at the same time.
Yeah, it's
tough. My girlfriend, yeah. So I believe we're all on the same track.
Okay. So today we're March 30th, and then I see this notice of a hearing that says, hey, we've got a hearing scheduled on April 13th to talk about a motion to modify the temporary parenting plan and the amended restraining order, which I guess kind of makes sense because today you're asking for a motion for default to have the parenting plan and everything ruled with what you asked for because there hasn't been a formal response.
Correct.
And then we're coming back in 2 weeks to modify that parenting plan that we just entered today potentially and modify the restraint order. That's where I'm a little bit confused.
Okay, so there, can you still hear and see me?
I can hear you. I can't see you anymore.
Okay, so it's just to dismiss the motion for to default and go from there. Might bring up the motion, the modified on the 13th for supervised visitations.
Okay.
Did you get that?
I think I got that because in your initial pleadings, you asked for a particular type of relief, and with a default, you can't change. Like, okay, now I asked for this, and I'm changing it. So you get what you asked for if you went on the default, And then if you want to change that, then you'd come back on April 13th to modify it.
Okay, yeah.
Is that what you're thinking?
Yes.
Okay. So that makes more sense to me after having you explained that to me. Let me just go on the initial motion here for your parenting plan. So here back on August 9th, you filed a parenting plan, a proposed parenting plan related to, is it Malaya?
Yes.
Okay. And it states that you're asking that there be limited decision-making, that you'd be in charge of school, education, and healthcare decisions.
Yes.
And that you would be nominated as the primary custodian, and that she would have, Ms. Young would have visits on Friday at 6 p.m. to Sunday at 6 p.m. every other weekend.
Sounds right.
Okay. And then you've got some holiday schedules set in there, and that the exchanges would be up in Toledo, a house up in Toledo. And so that's
it's a truck stop, but yeah.
Oh, CG's.
Yes.
Gotcha. Okay. All right. So that's what you're asking for. Okay, good. I think, thank you for your patience and helping me work through that. I appreciate that. Okay. Mr. Miller, has Ms. Young appeared at any of the hearings since the case has been filed?
Yeah.
So one thing that I was looking at on your proposed order for the default, it says, it's talking about notice for Ms. Taylor or for Ms. Young. It says the other party, Ms. Young, is entitled to notice of this motion for default because she appeared or was served with the summons more than a year ago, which I don't think that's accurate because it's not been more than a year. So the other option is that she's not entitled to notice of the default motion because she hasn't filed a notice of appearance and she has not appeared in this case in any other way and was served with the summons and petition a year ago. So I'm a little bit concerned that since she has appeared in the case, usually a default is like the other party says, whatever, or they don't contest what you're asking for. And so they don't show up for anything and just say that what that person wants, I'm okay with that. Here where she's, go ahead.
I think she was more kind of explaining like she hasn't responded to the case. So like she's not there.
Right. She hasn't formally responded.
Right. So I think that not more or less like she hasn't showed up to the case, just more or less like she hasn't responded. Like she showed up to court multiple times, but just never responds.
Right, right. And it looks like the contempt issue has already been decided. So we don't need to decide any contempt issues today because that was decided back on the 16th of March. Okay. All right, bear with me one moment. Have you, when we're talking about that hearing on the 16th or on the 13th, did you send her a copy of that notice for the hearing on the 13th?
Yes.
Okay. And then did you send her a copy of today's hearing or
I did.
Notice of that?
Yes, I did.
Let me pull up that first.
So the one thing, Mr. Miller, I'm inclined to grant the motion for default if I have a showing that she was given notice of today's hearing. Do you know if you filed some type of proof of service?
Well, so like, was this hearing scheduled from the last court date?
Good question. Let me check.
Because if that's the case, then she was most definitely aware of
it. Okay. Yeah, let me look. Last hearing was on March 16th. So I'll pull up the minutes from that date. She was present. You were present. And the court set the default hearing over to today at 9 o'clock. Court denied the contempt, rules on medication, third-party communication, disparaging remarks, sign a bench order. So that was done. And she was present, and we set over the default to today. There was quite a bit of discussion at the last hearing about the default. And she was present with the limited legal technician, Ms. Balcher. Yep. And the court set the default out to the 30th today. And then y'all talked about the contempt, not providing school clothes, visitation, Commissioner Cotterell, child support. Okay, so all that. And that set it over for today. And usually when a case is set over, the parties are present and there's an indication that this case is going to be discussed today and that something would be filed. So I'm going to say that there was
she was aware of it.
Yeah. I think that's true. So. Go ahead. Okay, let's see. Thank you. Thanks. Mr. Miller, the clerk kindly pointed out to me that on March 27th, it looks like Ms. Taylor filed a response to the parenting plan request. And she indicates that there's agreement in some portions and there's disagreement in other portions of the proposed parenting plan. So right. I think that puts us at a position where that since she's responded, the motion for default is, I think I need to deny that since she filed a formal response. We still have the hearing set on this coming 16th or the 13th, I think it is, the 13th, to address the parenting plan.
But I mean, she's still not here today. So that's now we go back on that question of you asking me, like, what do I mean by how she's not present in court? This is a good example of how she's here, but she's not here.
Right. There's kind of a pattern of not being present.
Right.
Yeah.
So I mean, like, and that's what I've been fighting this whole time.
Mm-hmm.
That's why my end is being prolonged.
Yes. Yeah. Yeah. And I can't disagree with you. I think here that the fact that somebody doesn't show up to court is somewhat frustrating. With the default, it's a little bit different because with the default, basically there's not a formal response, and that's what the court's looking at. Because sometimes people just say, I don't care, do whatever you want, get whatever order you want. And then the court do that. But that's not the case here. So she's filed a formal response, which says, okay, there is something in dispute that the two parties have divergent views on what should be the outcome of the case. So since she's filed that, and it would be very good if she were here, but she's not. So I think that's enough to deny the motion for default, simply because the court looks for at least some formal acknowledgement that there is a dispute or there's not a dispute. She's saying there is a dispute. Okay, so that means the case goes forward. So if with the docket notice sent out for the 13th, then we'll be here on that date to consider the motion that you filed.
Okay, I want to put on the record that she was not here today, though.
Yeah, clearly.
And it follows a pattern of her.
Yeah.
Okay.
Yeah, that's fine.
Okay.
Yeah, the clerk's minutes they always reflect who's present and not present. It'll reflect that Mr. Miller is here, and Ms. Young is not here.
Okay.
Notwithstanding the notice that she had that we were going to set it over to today, she's not present.
Sounds good to me. But so nothing's changing though on my end.
Right, as far as the motion
until the 13th.
Right.
Okay.
Yep, that's I think that's an accurate portrayal.
Okay.
Okay. All right. Thank you, sir. We'll see you in 2 weeks.
Thank you, Your Honor. Have a good afternoon.
Take care.
Cameron Miller and Taylor Young.
Taylor Young's here with me, Your Honor. Diane Lefker, limited license legal technician.
All right, and Mr. Miller, I see you're here. Good. Just a moment here. So there's a motion for temporary orders, a motion to appoint a guardian ad litem, and then the motion was to terminate a restraining order. I think procedurally where we're at is there's a temporary restraining order, and we're here today to actually hear the motion for the restraining order, and however that is entered, if it's entered.
Yes, Your Honor. And then the motion is for the hearing on the 27th. It just, all of it kind of flowed together.
Okay. I think we need to hear the evidence on the restraining order first. And we typically will do that by placing the parties under oath. So, Mr. Miller, I believe you're asking for the restraining order. So I'm going to place you under oath and hear from you first. And then Ms. Young, I'll place you under oath and hear a response. Okay? All right. So, Mr. Miller, do you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, Your Honor.
All right, thank you. What is your full name, please?
Cameron Christopher Miller.
Mr. Miller, is everything that you stated in your request for a restraining order true and correct?
Yes, Your Honor.
Okay. Tell the court why you're seeking a restraining order against Ms. Young in this case.
Well, let me see. Like, how do I explain this? I've had my daughter for the last, 2 years being down here. And I don't have my paperwork right here in front of me. So I've had my daughter down here the last 2 years of me working down here and me being in Cowlitz County. Taylor has DV stuff going on up there. She's got protection orders against people up there. And I need to make sure that my daughter is safe and in a good personal dwelling and staying in school. And she's not in any chaos environment. Like Miss Young had an incident up there at her personal dwelling where there was a DV case. I put all that in there, I believe. She has, I believe that was her boyfriend or something like that, whoever it was up there. But there was a domestic violence case reported. So she had to go get a restraining order on her ex, whoever named Drew Sturrett or something, and my daughter's seen that. And my daughter brought that to my attention, not to my attention, but also a teacher at school. And the teacher is called the CPS worker, and the CPS worker is now doing her job on that.
Okay. So you're saying your daughter witnessed the domestic violence between Ms. Young and this Drew person?
Yes, she had witnessed something to come back to me to tell me and to bring it up to a teacher at school, to where the teacher thought that's what was going on in our home, which I had to correct that. Me and my girlfriend had to correct that. Okay. To where I had to go and hunt down police reports, evidence of the incident that my daughter was talking about. And it is an actual legit event that happened at Miss Young's dwelling. Yes, that my daughter has knowledge of. I mean, she's 7. She's not going to lie. I'd be like, she's not going to lie about big stuff like that. She might lie about taking the candy out of the drawer, but she's not going to lie about something like that.
Well, and you were able to document it with police reports, it sounds like.
Yeah, I submitted everything to you guys.
Okay. You don't personally have a fear of Miss Young at this point, is that right?
Oh, no, I believe she would come to my house and start a whole ruckus. Absolutely, I do.
As relating to your daughter, though, right? Or do you feel threatened by her personally?
As she would harm my daughter? Yes, by not giving her medication and stuff like that, and not bathing her. All of it. Absolutely, there's harm there. Absolutely, there's fear there. Now, there's no doubt about it.
Okay, I guess I'm just wondering if you personally feel that you are at risk as a result or relating to Ms. Young.
Yes.
Okay. All right. All right. Anything else?
One moment. Oh, okay. So yeah, she has assaulted me previously. You know, like in the past, if you guys, I put that in there too.
Okay. All right. Thank you, Mr. Miller. You'll have a chance to respond to Ms. Young when after she makes her statement. Ms. Young, do you want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, ma'am.
Okay. What is your full name, please?
Taylor Carmel Lorraine Young.
All right, thank you. You've heard Mr. Miller, and I assume you read his petition requesting a restraining order.
Yes.
So how would you like to respond?
I would like to, I 100% disagree, because what he's talking about, the domestic violence, happened when Malaya was not there. She's never seen anything. She's never heard me and Drew yell. She might have, I'm honestly being honest about, she could have heard me over talking about something, but she's never witnessed anything. And
that's documented in the police report.
It's documented in the police report. And she was not there that night it happened either. Also, the restraining order, there's now one, and I thought it was in the beginning because from history with Cameron, as soon as the police were involved, there was a restraining order in place. Well, when the police came, and the next day a lady called me asking if I wanted to press charges and everything, and that he was gonna have court on a certain day. So I got under the impression there was already a restraining order. Didn't talk to him, haven't nothing. Then I get an email after we already went to court from the lady who called me from the court stating that he's been picked up and he was in custody and that there was a restraining order. And so that's where we are now. But my kid has never seen domestic violence and has never seen me and Drew fight either. But she's seen me and her father fight.
How long ago was that?
Like last year, like when we've been in contact, me and Cameron can't be in the same facility without there being issues. But as soon as that happened, I let it go. I've had domestic violence in the past you've read in the reports from Cameron, and I have not had contact with you ever since I saw those red flags, have not been involved since. And he never lived at the house.
You haven't seen your daughter for a few months now?
Yeah, about a month now.
About a month, okay.
And this was right after the last hearing.
And this was right after the last hearing. So I think it's in retaliation because he didn't get what he wanted. I've done everything that they wanted. I have my own place. She has her own room. I've done everything. I'm in the best point of my life now that I've been in my kid's entire life. And he's not letting me be a part of her life. And that is the problem.
All right, just hang on a moment here.
And he's the one with the warrant out for his arrest. What if he gets pulled over and my kid's in the car? Where does she go?
Can I state something, Your Honor?
Yeah, I'm going to give you a moment here. I'm just looking at the temporary parenting plan. Just give me a moment. So, Ms. Young, it looks like prior to this temporary restraining order being entered, you would see your daughter Friday to Sunday?
Yes.
And then I know I entered an order requiring that you provide the correct amount of medication for her.
Yes.
Okay. And then the temporary order on the restraining order was entered and that stopped those visits, right?
And I missed her for Easter. I didn't have her for my weekend, and she missed my dad's funeral.
Okay. All right, I'm going to give Mr. Miller a chance to reply.
Okay, so I want to put on the record that there was another court date that she missed just before this one. So I want to put that on the record because I'm pretty sure that the judge put on the record that she wasn't there. And then also, I don't have any DVs. Okay, I want to put that on record too. Miss Young has DVs. I want to put that on record that she pepper sprayed me and my daughter. You know, so I don't know what she's talking about, not having no DVs. The city of Centralia put a restraining order on her against me with my daughter. I want to put that on record, okay? And then, you know, I don't drive around with my daughter in the vehicle. My girlfriend does that because I drive all day at work, you know? And also, my warrant status has nothing to do with Cowlitz County, okay? And I haven't been in trouble with the law for over 3 years now going. And I've been doing pretty good working down here in Cowlitz County and doing tree work and stuff, you know, and my daughter's been doing pretty good down here in school, you know. The other thing is well, we're all under oath, okay? Taylor's declaration is pretty false advertisement. I want to state that.
In what way?
How she says that there was no domestic violence in her household with that Stewart guy. You can read her declaration and then you could go and read the legit police report and they won't add up. And then you can also go and read Melicia's police declaration, and she'll state that there was never Drew has never hit her physically or anything like that. That's false because Melicia states to the police that Drew hit her the day prior. And then Rhonda's allegations, those are actually pretty wrong too, because there was recently a new guardian ad litem out of Lewis County, I believe like 2 years ago, that Rhonda stated a whole bunch of other stuff too. And just like Miss Young, how Miss Young states that she's in fear for her life or whatever with me and blah, 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 blah. She actually tells the guardian ad litem in Lewis County that she's not. And, you know, and that we're co-parenting and all this and blah, blah, blah. So she's really out for a reach, it kind of sounds like, you know, and I'm pretty sure I put in messages, I submitted messages stating how I didn't force Taylor to sign a parenting plan, like a mutual parenting plan between us, because she went to a notary and had it done herself. Just like I went to a notary and I had it done myself. She also gave power of attorney and custody over at a time to my sister and signed the exact same kind of paper that me and Taylor came up to sign, but the one with my sister, I did not sign. You know, that's the thing. All of a sudden, Taylor wants to sit there and say that I'm out for like retaliation or whatever the heck she's trying to say. No, I could care less about that. Okay. It's about my daughter, for one. So, how she's like, she was not here at the last court date. I want to state that. So she's like coming in and out of it.
I saw that in the court record.
Thank you.
Your Honor, I was aware, I thought the court date was on the 31st.
And you had already filed.
And I already filed my response.
Oh, she was there.
All right, we're not gonna.
The judge asked me, Your Honor, the judge asked me that day on the court date, did Miss Young know about it? And I looked at him and I stated, I said, I'm not sure. Is this a court date that I sat or did you guys sit? Because if you guys stated it, then she most definitely knew about it. And he went back and he looked through his computer and he looked at me through the monitor and says, you're right, we set this. She absolutely did know about that.
All right, let's focus on the restraining order issue. My focus on this decision is I want to make sure that the daughter is protected. And so I'll acknowledge that there's in 2022, there was a temporary parenting plan issued. Apparently the parties followed that for a while. Then they came before me because of an issue relating to the administration of medication. I made an order relating to that. Apparently there were visits going on certainly into 2023. And then recently, Mr. Young has filed for another restraining order. He's provided evidence to the court of police reports that suggest that there was domestic violence occurring in Ms. Young's life. And that raises a concern in it, in my mind, supports a limited restraining order. And it's going to be limited as to time. One of the other requests by Ms. Young is for the appointment of a guardian ad litem. Mr. Miller objects to that, but given the allegations of the parties, the concern about the domestic violence in Ms. Young's life, I think she has some concerns about Mr. Miller. A guardian ad litem is absolutely important in this case. So I'm going to enter a restraining order that will prevent Ms. Young from seeing her daughter. I'm going to enter it for up to 90 days. It may be that less than that, I'll change it. I also want her to be able to have telephone or video contact with her daughter twice a week during that time. And I'd say up to 90 days because I'm not sure how long the guardian ad litem report will take to generate. That could take a while, but if it can be done in 60 days and we can make some decisions, then probably simultaneous with getting that report, I would lift the restraining order and we would look at another type of parenting arrangement. So, well, let's take care of appointing the guardian ad litem at this point. So what we usually do is give 3 names. And if you happen to know any of these parties, you have the ability to strike 1 name. So the names are
Twyla Corey, Keith Lawrence, and Heather Call.
All right, so I'll repeat that. It was Twyla Corey, Keith Lawrence, or Heather Call. Do any of the parties know any of those folks? Okay.
No.
All right. So typically then we would appoint the first person on the list. So that will be Twyla Corey. I will give her your contact information, and then she will reach out to both of you and do an investigation. Initially, the order will require that you both pay half of her costs. If you're receiving state assistance or you cannot afford her costs, you can file a declaration with the court, and I can consider that and potentially have the county pay for your half of the costs on that. Okay.
Can I ask something?
Sure, go ahead.
Okay, so in Miss Young's part, she did state that like I pay her portion. Yeah, how you just stated that like the county will pay her portion. That's correct, right? Like I'll pay my portion, but I don't want to pay her portion.
If she probably asked for that, I'm not ordering that, and I hardly ever order that. I think both parties need to have some interest in the guardian ad litem, and I think having one party pay for it gives the other party a chance to say, well, you know, since they paid for it, the guardian ad litem is slanted their way, and I don't want that to ever happen. Okay. So it's very rare that I have one party pay the whole fee. But if Ms. Young cannot afford her half, then she can again file a declaration, and I can consider it.
Your Honor, we do have a hearing coming up on the 27th where we filed a motion for an amended parenting plan. That's where we were going to address the guardian ad litem. However, it is very restrictive to have no visitation and phone calls when this domestic violence did not occur when the child was there, as noted in the police report, and never was on the lease. Mom should have some visitation, even if it's at her mother's house, where the child isn't being restricted from the mother. In light of this other hearing coming up, it does take a long time to get a guardian ad litem, and we do want a guardian ad litem to be reviewing everything because there is serious history of domestic violence and criminal events in this case. There's manipulation.
Why is she talking? I thought she was
Mr. Miller, just hang on.
There is definite retaliation because the motion that he filed was directly after you denied him his contempt. And so she hasn't even had time to have time with her daughter. She should have some visitation, even if it is supervised, if that's what you want to do outside of her home.
Because I can stay at my mother's on my visits, and that's surrounded by my grandparents and her. I don't have to be in my home, but I can't go not seeing my kid.
Mr. Miller, any thoughts from you on?
Yeah, I got a lot of them. So for one, I got a question. Is that lady a lawyer or just a legal technician?
She's a legal technician. I'll let her speak.
Is she allowed to speak? Because
she is.
So when I last looked them up, they weren't allowed to speak. They're just there to do paperwork to help you, not speak.
All right, let me ask.
So, okay, so the other thing is like, yeah, I'm not okay with any of that because her grandparents and her grandmother, they all talk bad about me too. So, and they still allow Taylor to take Malaya places, even if the courts said no. So, no, I'm not okay with that because that's happened in the past.
All right, here's my concern about, I guess what was just indicated is the record that I've looked at on this motion shows that there is some domestic violence that's affected Ms. Young. And that could affect the daughter. And I need a guardian ad litem to look into this before I feel comfortable making a change at this point. So I am not going to order supervised visits at this point. I think if a guardian ad litem looks at this and even before the report is issued indicates that would be safe, I'll consider it. But at this point, I'm going to have the two either telephone or video visits until we get a guardian ad litem reflection on this case. Do we need to set specific dates for the telephone and video visits and dates and time, or is that something?
I would like to at least do one video call where she can watch Malaya at practice, please.
At practice, meaning sports practice?
Yeah, softball practice.
Well, how is she going to be able to talk to her then? I mean, the whole purpose is for her to communicate with her daughter.
That's right.
If you want to Zoom her in or FaceTime her in to watch her practice, that's great. But I think there needs to be 2 times where Miss Young can have a conversation with her daughter.
What do you got? I mean, yeah, any day that's okay with her. Malaya is at school from 8 to 4, and then after that, she's home. Malaya's got softball practice on Mondays and Tuesdays at 5:30 to 6:30.
Miss Young, what dates would work for you?
Thursday, and I can do it anytime.
It's her first game.
Okay, so Monday and Thursdays at,
I think Monday, what time?
6:45?
6:45, 5 o'clock.
Let's do 6:45 because she's at practice, I think 5:30 to 6:30.
Next Monday, is that the 17th?
I believe so.
That's going to be Malaya's first game at 6 p.m. to 7:30.
Well, there may be dates that get in the way. So let's say
no, that still works for me. It's fine. It still works.
How about Monday and Thursday at 7 p.m. And if the game gets in the way, then it will be whenever the game is over and she's back at the house.
Okay.
All right. I still want it to occur on Monday and Thursday.
Yes.
All right.
Monday and Thursday at 7 p.m., Your Honor.
Let's do 7 p.m.
Okay. Thank you.
For how long?
And for as long as the daughter wants to talk.
Okay.
Okay. And Mr. Miller, you're not to interrupt that. You're to provide a space where she can talk to her mother on her own. Okay.
In private?
Yes.
In her room is fine. In private, I don't want the child to feel like somebody's looking over her shoulder.
Okay.
Okay. All right. I'll do a bench order then. In fact, I'll appoint Ms. Corey. Let's set a review. Well, we have a hearing coming up on the 27th.
Yes.
Okay, I'll just see everybody back here then at that hearing, and then we'll set a review out from there.
Okay. Thank you, Ron.
The guardian ad litem. All right. Thank you. Ms. Young here.
Your Honor, my name is David Camisa. I was just hired to represent Ms. Young on this hearing today. I'm putting in my notice of appearance shortly, but I'm prepared to proceed today.
Okay. Mr. Miller, you're here. I see Mr. Miller's got a motion to waive the GL fees. That is going to be heard next week. So we'll deal with that next week. Well, I don't see the guardian ad litem, who is Twyla Corey, here, and I wanted to hear from her regarding visits with the mother. But Mr. Camisa, if you want to be heard on that, you may.
Yes, Your Honor. I'll be brief. Here, the court entered a temporary order requiring Ms. Young to only have Zoom visits with the child. Ms. Young respectfully requests that this order be amended to the original plan with unrestricted access to time with the child. Here, the court had concerns about a recent incident of domestic violence in the Young home. The incident involved Ms. Young's new domestic partner kicking in a door. However, this incident did not involve the child. In addition, the child was not present during this incident. Either way, there's no domestic violence charges against Ms. Young and the child, nor any convictions involving the child. In addition, we do not have any CPS investigations, nor any substance abuse present. Ms. Young has in fact missed 6 weeks with the child pending a GAL report. In fact, a prior GAL report in Thurston County actually awarded her full custody. As such, this GAL report will likely reflect a positive ruling for Ms. Young. It's in the best interest of the child to have unrestricted access to time with both parents, absent any limiting factors which are not present here. Ms. Young has a 2-bedroom apartment and was the sole provider for the child for 5 years. The child would have its own room. The petitioner was absent from the child's life during this time for 5 years. The child is in fact 7 years old now. As such, the petitioner has only been involved in the child's life for 2 years. The petitioner does not have an adequate residence for the child. The petitioner lives in a 2-bedroom apartment with 3 other children living there. As such, given that no domestic violence against the child is present, and Ms. Young has been the sole provider for the child for most of their life, I would ask the court to remove the requirements that Ms. Young only speak to the child through Zoom and award her sole custody.
Absolutely not. All right, so is it my turn to speak now, Your Honor?
It is. Mr. Miller, go ahead.
Okay, so I just want to go back on whatever he was saying about Miss Young being the sole provider for 5 years. That's wrong. She hasn't been the sole provider for 5 years, actually. My sister actually was there for 2 years, okay? And he also needs to go back to like the Thurston County thing to where the guardian ad litem granted her custody. That's false advertisement, you know, because there was a Thurston County case, there was a Lewis County case. Oh, wait. And in the Lewis County case, they still deemed me the right parent, okay? So, and then the other thing is you can't sit there and say like she doesn't have any custody, domestic violence cases against her, because if you need my proof, I will send it right over to you from Centralia PD that states that she did pepper spray her own daughter and me in my own home, in my own personal dwelling. And if you think I'm wrong, that means you're telling me that a public servant's records are wrong. That's not true, you know? The other thing is it doesn't matter how many children are in my home or how many bedrooms I have, as long as they are all sleeping properly. I don't have my son sleeping in their room. It's 2 7-year-old girls and they both have their bunk beds. Who in their right mind is all of a sudden saying like, that's not okay? It's not like I have a 7-year-old and a 7-year-old boy living in the same room. Absolutely not. So That part needs to be thrown out too, because that's false advertisement. And the other thing is like I said, the last court date, Taylor's letters of recommendations, they're all false. You know, you can read them and then go read police reports. None of it adds up. None of it adds up. And I've been in Cowlitz County for over 2.5 years now. Okay. And I've been stationed and I've been pretty stable. You know, I don't go from job to job. I don't go from apartment to apartment. I'm stable. I'm planted. I'm rooted in Cowlitz County. And I've talked to the GAL last Thursday to set up an appointment on that. But, and then about like her missing her visits on Zoom. Taylor is 27 years old. She was at the last court date when the judge set the court dates for video Zoom. And she still does not show up. She comes up with excuses. Like if a 7-year-old can remember the days and the time, there's a problem. It kind of sounds like she's honestly not doing what she's supposed to be doing, like I've been trying to tell. Because there's no way in heck that a 7-year-old is able to remember the time and the date of the Zoom meetings, and you as a parent are just constantly, oh, I forgot, it's not working, blah, blah, blah. Well, they're like excuses. Everybody's got them. Sometimes your excuses run out.
Okay. Thank you, Mr. Miller. Mr. Kamisa, any response?
Yes, Your Honor, I'll be brief. Analyzing the petitioner's recent testimony, he quoted, according to his own testimony, his sister's involvement in her life during that 5-year gap, not him. This was specifically referenced within his testimony recently. Regarding the Thurston County GAL report giving Ms. Young full custody, that's referenced as an exhibit. I could bring it up more, but I believe the court has already seen it.
No, you're wrong. Because Miss Young signed a paper.
Mr. Miller, Mr. Miller, one at a time, Mr.
Up to me.
Mr. Miller, Mr. Kamisa's speaking. Go ahead.
Thank you, Your Honor. I'll only have a few more things to say. In regards to the petitioner's claim of domestic violence, I would expect him to submit proof of that before just dropping it on the record. Without such proof, it's irrelevant. Moving forward, analyzing his personal living situation, it clearly does matter if the children have their own bedroom. It clearly does matter if there's 3 children living in one room. It matters if there's 5 people in a 2-bedroom apartment, especially when 3 of them are young children.
Girls is not an issue.
All right, let's stop. Mr. Miller, you're going to stay quiet while Mr. Kamisa speaks. Otherwise, I'm going to mute you and you're not going to get any more to say during this hearing, okay? There's a decorum that we're going to follow and you're going to follow it. You understand? All right, Mr. Kamisa, continue.
Thank you, Your Honor. I would just close and say I respectfully request that Ms. Young be allowed time to speak to her children without Zoom and be awarded sole custody as she's had for 5 years present to this hearing.
Mr. Miller, if I were to consider a supervised visit, is there someone that you would trust that could be involved in that?
Yeah, my sister.
Ms. Young, would you be comfortable with that as what I could do until I hear from the guardian ad litem?
Yes, Your Honor.
Okay. All right, I want to leave the video visits in place. The history of the Cowlitz County case is that Mr. Miller has had primary custody all through the case. And I have seen the different orders from, I think, Thurston and Lewis County. But I think I need to track what we've done here in Cowlitz County until I hear from the guardian ad litem. Unfortunately, she's not here now. We are going to be back next week on Mr. Miller's request to waive the guardian ad litem fee, and I'm going to try to make sure that she's here then. What I would like in the interim, today is the 27th, I would like a visit with the child on Saturday. Let's go from 10 to 2. And in the future, I may expand that if we continue to have supervised visits. But from 10 to 2, supervised by Mr. Miller's sister.
Right. It would need to be like 9 to 1 or like 8 to noon. I believe my sister works at 2.
Okay. Thank you for letting me know that. Ms. Young, can you make it 9 to 1?
Yes.
Okay. So we'll do it 9 to 1. If the sister can do the transporting, I think that would be best so that Mr. Miller and Ms. Young do not have to contact each other.
Your Honor, would it also be okay to be at my grandparents so my grandparents can see her? He knows that is a safe environment.
I don't see a problem with that as long as the sister is with you at the same time. Okay. All right. Just hang on. I might. Oh. That's fine. All right, then we'll check in with everybody next Thursday to see how that particular visit went. And I may consider expanding it a bit at that time. Okay, everybody understand?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. We'll see you next week. All right, Cameron Miller and Taylor Young. No, I saw him just Young here.
Your Honor.
All right, good morning.
Your Honor, this is David Camisa. I'm here for Miss Young this morning.
Okay. Ms. Young has brought a motion to waive the GAL fees. Do you want to address that, Mr. Camisa?
Yes, Your Honor. Ms. Young is experiencing financial hardship as seen in the motion and just asked the court to waive the fees for the GAL.
All right. Mr. Miller, do you have any comment on this particular motion?
No. I still need to get my GL part done now.
All right. So I read the motion. Let me turn to. So Ms. Young has indicated that her gross pay each month is $26.78 and her take home is $23.08. And she supports 2 people, herself and a child. And the guidelines for 125% of poverty level, which is at the point we can waive the GAL fees and have the county pay for it, is $2,066, and that's gross pay. But even if we looked at that in terms of net, she's above that threshold.
Can I state something, please?
Sure.
So how does she support 2 people if Malaya resigns with me? That would contend that she only has herself that she takes care of.
Okay, well, we get to the same place here, which is she, even on a net basis, is making above poverty level. And so at this point, I cannot grant the motion. And let me ask you, do you know if she's receiving any state benefits? Mr. Camisa?
No, Your Honor, I don't believe so.
All right. So based on the guidelines that I have, I'm going to have to deny that. Let me hear from Mr. Miller, and then Ms. Young, I'll hear from you. Mr. Miller.
No, I don't have anything to say right now, Your Honor.
All right. Ms. Young, go ahead.
I was gonna say I did before refute. I had food stamps, but those were canceled like back in February.
Okay, but you don't receive them now, right?
As of like 2 days ago.
Mr. Miller, how long have you been the primary parent?
With Malaya?
Yeah.
I'm going on 3 years now.
Okay. All right.
No.
Well,
I'm not going to argue.
I'm, again, I was given a declaration of what the earnings are. The earnings are above the threshold that I have to work with, even assuming there's 2 folks in your household. So I'm going to deny the motion. All right. Thank you. Next up, we have Pamela Pascal.
Oh, wait. Hey, Your Honor, sorry. Am I free to go?
Yes, you're free to go.
Oh, okay. Thank you.
On to the next case.
Bye.
Okay.
That judge is fucking.
All right, I'll do that. Cameron Miller and Taylor Young. I see Mr. Miller. I see Ms. Corey. Mr. Camisa, you're here for Ms. Young, I take it?
Yes, Your Honor, that's correct.
And we need to know, is Ms. Young here? We just need to reflect that in the court minutes.
So I have a question about that. If we're on the self-represented docket and she's self-representing, how come is it that those guys are always allowed to speak for her? If we're on the self-represented docket.
So attorneys can appear for clients in this docket.
I've never got anything saying that she was being represented by him.
Just a moment here. Have you done a notice of appearance, Mr. Camisa?
No, Your Honor, I'm just filling in to help her.
So you're not her attorney?
Are you a lawyer or are you in?
Yes, Your Honor, I'm an attorney. I'm just filling in to help her. She's actually technically hired a limited licensed legal technician that works in our office.
Right. So,
and given the complexity of the case, I'm just filling in to help.
Right. You have no say here. Sorry.
I'm going to let him speak.
So she is being represented how though? Because the legal technician is just a paper pusher.
I understand that they fill out the documents, but it's through a law firm where Mr. Camisa works. And so I'm going to allow him to speak.
Okay.
All right. The last thing I did is I denied the GAL fee waiver on behalf of both people. There was a motion for a revision that got assigned to a judge yesterday. And there were issues with visitation that occurred over the last couple weekends, I guess.
So I got a good question about that part too.
Yeah, let me know where we're at on the visitations.
Okay.
Go ahead, Miller.
We're still doing the Zoom. Yeah, we're still doing the Zoom. And then the last visitation when she physically seen her was supervised visitation. And that's my most concern. So they were supposed to meet at the grandparents. She texted my sister to have her meet in Grand Mound at Walmart. And I'm under the impression when you're doing supervised visitations, it's with that supervised person and at one location, not out doing a whole bunch of running in errands. And my sister filled some stuff out stating that that's exactly what they did.
Apparently your sister indicated she was uncomfortable being at the grandparents' house. Have you talked to her about that?
Yeah.
So if that's the case, then...
So no, Taylor manipulated that whole thing to my sister. That's how that went about, because Taylor tried to say that I told her 9:30 when that's not what I told her. I told her 9 and to be at the grandparents' house. In the next court date, I'll have my girlfriend submit everything that I stated. Okay, because I stated it is at the grandparents' house. Nobody is to leave. That's not how it worked and all of that. You know, I even told my sister she didn't feel comfortable. Well, you don't have to do it. And I'll go back to court and I'll have the judge, what is that? The person that you can pay, I don't know, you pay a facility and then like
that's a professional supervisor.
Right. Okay. But all they did is run around and did errands.
I did read that, but I guess I'm wondering, is your sister uncomfortable being at the grandparents' house? And if so,
she's uncomfortable being around all of them.
Is there another location that we could set this?
No, we can do that person at that, the professional person.
So your sister's out of it at this point?
Yep. And that's just where I want to do it. I don't want no more games. I don't want no more hassle about it. If I have it at the facility, then I know there's just no ifs, ands, or buts about it.
Mr. Camisa, do you want to respond?
Yes, Your Honor. According to Ms. Young, she's reported that Mr. Miller is engaging in conduct that is obstructing her time with the child. According to Ms. Young, the in-person weekend visitations were at the last minute. Mr. Miller changed the location and the time, which is very concerning considering it's something that was agreed to just basically a few days before that. In addition, during the weekly Zoom visits,
I hope you got your facts straight.
Ms. Young was
Mr. Miller, you need to remain quiet while he speaks. Go ahead, Mr. Camisa.
I'm almost done, Your Honor. Miss Young reports that she was not able to exercise her visitation as the child couldn't come to the Zoom as they were showering after a sporting event. In addition, Miss Young reports that she gave a photo or a painted picture of the child detailing love and affection that Mr. Miller gave away. The only thing I would really ask is that with Mother's Day coming up this weekend, that Miss Young be allowed to see the child. However that can be achieved. If it could be done without a professional supervisor, that would be great. But if a professional supervisor is necessary, I would just ask that Mr. Miller bore the costs of it. Or alternatively, the costs be shared between the parties.
So can I speak again now, please?
Go ahead.
Okay, so, I will admit, I put a fan in my room. Okay, there's nothing wrong with that. And I told my daughter to sit down on my bed. So there ain't nothing wrong with that either. And I won't be paying for Taylor to see her child. Miss Young can pay to see her own child. I'm not going to split the cost on nothing. Nothing about that. And I did not switch the visitation. I didn't switch no meeting spot, no nothing. I texted my sister and I said, if you don't feel comfortable, cancel it. I have no problem with you canceling it, and I'll go right back to court and I'll tell the judge that. So somebody needs to get the facts straight, Mr. David.
All right, I'm not going to have any sarcastic comments on this docket, Mr. Miller. All right.
Well, it's just really getting
Mr. Miller,
old with like them saying what they think I said when I know I did never say that. I have text messages.
I'm ready to make a decision. I don't have anything from Mr. Miller's sister saying that she doesn't want to be involved in the visitation. And consequently, I'm going to assume that she's still willing to do that. I'm going to order a visitation this Saturday from 10 to 2, supervised by Mr. Miller's sister.
Okay, so I need to check with my sister if she's willing to do that right now.
And that can be at a public location.
I need to check with my sister.
A park. It's going to be a nice weekend. Doesn't have to be at the grandparents' house. It can be at a public location.
Okay, and if my sister doesn't want to do it?
Your Honor?
Just a moment. Then she'll have to file a declaration with the court.
Who, my sister or
yes.
Taylor?
No, your sister.
Okay, that can be done.
Okay. Ms. Young, I think you wanted to say something. Typically, when you're represented by an attorney, that we have the attorney speak for you.
Yeah.
All right. The drop-off on Saturday will be at the grandparents' house, and then the sister and Ms. Young and the child can go, and Malaya can go to another location. Okay. All right. Thank you, everyone.
Your Honor.
Yes, Ms. Corey, please.
This was also supposed to be a GAL compliance review.
Okay, I'm sorry I didn't give you time to speak. You want to give us an update on that?
Sure. Actually, this case has just recently received it. I have intakes out to both parties. Just this morning received Mr. Miller's. I have not yet received Miss Young's intake. Also, I've spoken with both of them and indicated that payment is due this week, and made arrangements for that. Have not seen payment yet, and would ask the court to schedule another compliance review in a couple of weeks to assure that we have gotten the payment process started and that both parties are cooperating.
Okay. Ms. Young, I want to encourage you to get the intake paperwork back to Ms. Corey as soon as you can. Ms. Corey's asked for a review in 2 weeks. That would be on May 25th. So I'll see both parties back here on that date. Okay. All right. Thank you. All right. Cameron Miller and Ms. Young. See, Mr. Miller's here. Taylor Young is here, and Mr. Camisa is here. Let me start with Ms. Corey. Have you had a chance to investigate this case? And if so, where are we at?
Well, I have not. And neither party has, as of yet, made effort toward paying the GAL fee. I have received completed intakes from both parties, and I did also make arrangements with them to pay the fee in lesser payments. I have not received any payment from either party as of yet.
All right. Mr. Miller, are you planning on making that payment?
Yeah, it's just slipped in my mind. I've just been busy. I can make it by Monday or today.
All right, thank you. Ms. Young, are you? Go ahead.
I did speak with Ms. Young yesterday. I apologize. And she indicated that she has a payday early next week and hopes to be able to make a payment time. However, I'm thinking that this has really been a struggle for both of these folks, and we learned that county pay was not an option. I hesitate to keep that offer of partial payments because this has been so difficult too.
I'm not sure what you mean when you say you hesitate to keep the offer of partial payment. Are you looking for full payment?
I would say that if I don't receive the agreed to payment within the next week from both parties, that I would have to rescind that offer of a payment plan and ask for full payment.
All right. I saw the declaration from Victoria Miller. What happened regarding the visit this Saturday, last Saturday? Mr. Miller, you can respond.
Well, I tried to explain it last time that my sister just didn't want to have anything to do with it. And then you told me that she had to fill out the declaration stating that she didn't want to do it. And that's where we are at.
Okay.
I did find, I believe I have somebody else that's willing to do the visits. So.
Who is that?
My next door neighbor, Cassie.
Okay.
No. I don't know who that is.
I need some information. So Mr. Miller, don't tell me the address, but where do you live? What city you live in?
Longview.
Okay. And Ms. Young, where do you live?
I live in Olympia.
You're in Olympia. Okay. And I saw a previous order where you did exchanges at GC's truck stop. Do you know if that's something that would be still be available?
I feel Centralia's even. It's a middle way from Olympia to Longview.
No, we can still do Gigi's truck stop.
And is Cassie, I'm not saying I'm going to agree to Cassie, but are you saying Cassie is willing to do that, be part of that transportation?
The transportation or supervised visit?
Well, supervised visits.
Yeah.
If
and the transportation, yes.
Okay. All right, Ms. Young, I'll give you a chance here and give your attorney a chance. Okay. All right, Mr. Kamisa, do you want to address where we're at?
Yes, Your Honor. Given there seems to be a continued issue with the supervised visits, if Ms. Miller is largely unavailable to supervise, I was going to propose Ms. Young's grandparents be the supervisors.
Yeah, right.
There doesn't
took my
appear
daughter
to be
from me last time.
Mr. Miller, you need to remain quiet when the other party is talking. Thank you. Go ahead, Mr. Kamisa.
Thank you, Your Honor. I mean, given that it looks like Ms. Miller is likely going to be ruled out as a supervisor now, I think having the grandparents step in is likely in the party's interest, given that we need to find someone to do the supervision. There's no real reason why they cannot do the supervision. I understand Mr. Miller doesn't want them, but at this point in time, there's no necessarily reason or even provable reason why they can't step up as the supervisor at this junction.
Where are their grandparents located?
Centralia, that's where the original place was that Victoria would meet us at. And Cameron knows that that is a safe environment. He knows that. Everyone knows that that is an okay place for my child to be.
All right, let's give Mr. Miller an opportunity to respond.
No, the grandparents, I'm not comfortable with it because when all of this whole stuff started, the grandparents were the ones who, manipulated me to give my daughter to them. That's 3 times running that they have done that to me. No. That is not even.
Ms. Young, you need to remain quiet. I don't understand what you mean by they manipulated you to get the granddaughter to you. What does that mean?
Okay, so like literally a week and a half before school started, the grandparents came down, asked to see their granddaughters, shoved her in the car, and then took right back off to Centralia. Oh, I still have the text messages that I will be putting in today from the grandfather, stating that I don't have any rights to my kid. The mother, she needs to be with the mom. I messed up somehow. That Malaya is not going to be coming back to me. Oh, yeah, that's all from Jim Bartley. So absolutely not. And if they don't want to have Cassie do the exchange, I'll be more than happy to go with an actual legal person at a facility that I'll have her pay for.
Tell me a little more about Cassie. How old is she?
She's about 35, maybe. I know she's in her between 30s and late 30s. How old is she? She's 33. What's your last name? Salisbury is her last name. And she's the girls' youth group. What? The girls' youth group leader at church. So I can't be angry and fight her. She's willing to do it. She said she's willing to do it, but it would have to be next Saturday. I'm willing to do Zoom this weekend. I'm going camping. I'll try to find some time. I'll try to find the service so they can talk on Zoom. But Cassie said she'll be willing to do it next week to start the supervised visitation.
All right. Ms. Young, you've heard this discussion. I guess I don't want to make a decision unless I give you an opportunity to make additional comments.
I do not know who this is, and the fact that Cameron doesn't even know her age or her anything, and that's the trusted person for supervised visits, I don't understand that. I work, I have my own place. There's absolutely no reason I should not be able to see my kid, nor my child loves her grandparents. If it is at my grandparents' house, she'll be able to see my mother, me, and her family all under one roof. It is a safe, clean environment, and he knows that. And everyone knows that. And this is starting to be about a month and a half of me not seeing my kid. I don't know what's being said on her end on why she's not seeing me. And I need to be able to see my kid.
All right. I agree with that.
Cameron his options. He's had multiple chances. I did it with Tori. I did it with everyone. I gave him his options and it's not working. And I would love to try my way. And that is to be at my grandparents' house. And I don't need supervised visits because we wouldn't leave.
I'm going to accept Mr. Miller's statement, though, about the grandmother's or grandparents' attitude towards him, which creates
He's threatened my grandparents. He's threatened to kill my grandfather. He's done all these things and they've done nothing. They never kidnapped her, ever. They never just took her from him. He just does this when he doesn't get what he wants and everyone has to pay for it. This is what happens when things don't go his way. He takes the people who love Malaya away from her when it doesn't go the way he wants it to. And that is just the truth.
So yeah, I will be putting in my text messages from the grandfather today, so we can get all of that cleared up.
I also have text messages and stuff. I only received that Cameron forged his sister's signature, and the statement is not correct.
That's falsely wrong. So I'll have my sister come to court next time too, I guess, and get her under oath and have her explain that part too.
All right. Let me go back a bit. The parties had and have a temporary parenting plan in place, which gives unsupervised visits to Ms. Young every other weekend. Then the issue with Drew Stewart came up, and out of an abundance of caution, the court suspended those visits in order to investigate the relationship between Drew Stewart and Ms. Young, and to make sure that Mr. Stewart was not in a position to cause any harm to Malaya. I appointed a guardian ad litem because of some delays in payment and other things. I really don't have a report or any indication from the guardian ad litem as to what is in the best interest of Malaya and what's going to keep Malaya safe.
Malaya,
I'm sorry. So
I haven't had contact with Drew ever since. There's a no contact order.
Ma'am, let me just keep going. I need to sort my thoughts, and it takes me a little while to think through them. Okay? All right. So at this point, the court feels that supervised visits are still warranted until we get to a point where I know that Malaya is going to be safe. When we initially set up supervised visits, Mr. Miller indicated his sister would be willing to do that. She's now said she wouldn't. And so we need to find somebody else. And I'm somewhat hesitant to appoint somebody that Ms. Young does not know. And it sounds like Mr. Miller doesn't know very well. On the other hand,
I mean, I know her. I just don't know like her age.
On the other hand, the whole time that Ms. Salisbury, well, at least most of the time she'll be with Malaya, so will Ms. Young. And it's hard for me to imagine that Ms. Salisbury would be any kind of threat to Ms. Young.
Would he be okay with my stepmom?
No.
I think I want to try Cassie Salisbury next. And honestly, the best thing that can happen is to get Ms. Corey paid so that she can do her investigation so that we can move forward with this. All right. Mr. Miller indicated that he's leaving this weekend. Do we have Zoom visits at 7? At some point?
That's what I meant. I'd try to find service for the Zoom.
Okay. Let's have a Zoom visit this weekend. Tell me what date and time that's going to occur, Mr. Miller, so that we're not confused about that.
Oh, we can do Saturday at 7.
7 p.m.
Yeah. Or
right.
Can we do earlier? Like 3 or 4?
I'll be at work.
Well, what time? What time's good for you?
I get off work at 5.
Okay, we'll do 5. 5, 6.
Better do 6. All right, Saturday at 6 will be a Zoom visit. Nobody should be interfering with that. That should be a discussion just between Ms. Young and Malaya. The next Saturday will be a supervised visit. And I'm just looking for an order here, just a moment. Oops. Growing up, and now we live in the find out era. So like we were born and we lived there for a couple of years, and like we just do it. There's money everywhere, and everything was great, and then now we're in the find out. I'm still going through the file here. Just give me a moment. All right. The next Saturday, and that's going to be June 3rd. I want Cassie Salisbury to meet Ms. Young at GC's.
Could we do a visit at her baseball game so I can see her at baseball?
Where is that? Down in Longview?
Yes, but I would love to see my kid play baseball.
Do you know when that is?
On Mondays.
Okay.
So how does that work with the restraining order, though?
There shouldn't be a restraining order.
I'll tell you in a moment.
I don't mind standing on the other side of the field.
Let's talk about the Saturday visit first. So are you going to want to go up either? Well, what would be your thought on what you would do with Malaya on the Saturday visit?
She wanted to go to the Hands-On Children's Museum last time I talked to her. That's what we were going to do. We usually go to the park. We went and got our nails done last time, but she wanted to go to the Hands-On Children's Museum.
And where is that?
Olympia.
It's in Olympia. Okay.
The door is open. Samantha's in her room.
Okay. All right. Well, let's meet at
Or we're going to take her to go see the mermaid movie, The Little Mermaid. I'd like to take her to see that.
Okay. Let's meet at GC's truck stop at 10 a.m. on June 3rd. And we'll have Cassie Salisbury bring her there. And then Cassie Salisbury will need to accompany them on whatever outing they have. If that goes to Olympia, she'll need to go to Olympia. And then I'd like a return to the GC's point by 6 p.m. on Saturday. And then Cassie can bring Malaya back to Mr. Miller. I know that sounds a little bit convoluted, but I'm not willing to take a step towards unsupervised visits at this point till I hear from the guardian ad litem. And I want to do what I can in order to get you in-person visits with your daughter. In terms of Monday baseball games.
Sorry to interrupt. They just said that Cassie can do 2 to 5 on Saturday.
2 to 5?
Yeah, that's kind of short.
Cameron, can you please swallow your pride for once and know that is it okay that she's with my grandparents, and you know this. And with
the visit on
is
the
how
visit,
sorry.
The visit on Saturday is going to be 10 to 6. If Ms. Salisbury can't do it.
Okay, that works.
I really hope it works.
All right. The Monday baseball games, I'm going to allow, there needs to be a 50-foot distance between Mr. Miller and Ms. Young at the baseball game. Malaya will be able to come over, talk to Ms. Young, but obviously can't leave with her. And Ms. Young will be able to observe the game. You'll have to obviously be on separate parts of the baseball field.
Thank you, Your Honor.
All right. Okay. All right. So we'll do that.
And if Cassie can't do it on Saturday, what happens then? Because I didn't get to see her last week either.
I know. I'm probably going to have to put I hate having you come back so often, but it looks like I need to track this. We're going to need to come back on June 8th to see if that visitation occurred and to see how the baseball games go.
Okay.
I don't know that Ms. Corey's going to have any conclusion by then. Probably not, but I want to check to see how these are going. And if they don't go, then I'll have to make some other decisions. Okay. Yeah. Mr. Kamisa, any comment at this point?
No, Your Honor. Sounds like everything's been discussed. Thank you.
All right. Thank you. I'll do a bench order to that effect. And we'll see everybody back here, I guess, in a couple weeks on June 8th. Thank you.
Thank you.
Thank you.
All right, let's go back to Cameron Miller and Taylor Young. I see Mr. Miller. Can you unmute yourself, Mr. Miller? Oh, there you go. Good. And Ms. Young is here and Mr. Kamisa is here. And Mr. Kamisa, did you see the declaration by Chandra Muncy?
No, Your Honor, I haven't seen it.
Ms. Taylor, did you get a copy of it?
Of the what? What did I get a copy of?
The declaration by Chandra Muncy.
No, I did not get that.
Okay. All right. Well, she gave her impressions of the visit that occurred recently. So I wanted this hearing to check in on how that visit went and to decide how we're going to move forward in the future. I think what I need to do is read you portions of this. I don't want comments about it when I read it, because you may react to it, but I want to make sure we all have the same information.
Okay.
So starting at where there's a meeting at GC's truck stop, she writes, at that time, Rhonda came outside and also asked if Malaya was ready to go, insinuating that we would get into her car at that time. I also let Rhonda know that was not the plan and that Malaya and I would be in my car following them to the destination. Rhonda immediately got hostile and started saying that I was not right and that this was BS. I told Taylor to call her attorney, and then I repeated myself to Rhonda that I had a copy of the paperwork and that Malaya was not going to be getting in the car. Then apparently Malaya stayed with Ms. Muncy, and Taylor drove with her mom. They went up to Centralia. They saw some people. I think they went to the Children's Museum, or they were planning on doing that. I guess they did go to Applebee's in Olympia. And then she shares some of her thoughts that I'll read. Moving forward, I would not mind subbing for the visits. And that is because the initial supervisor was to be Cassie Salisbury, but she was ill. So I appreciate the parties working to find a substitute. I want to say that. She writes, everyone was respectful after the initial meeting. However, I do believe that there needs to be better guidelines for these visits. It was a very long day for everyone involved, and it was very overwhelming for the amount of people included. I would also like to see Taylor take control of the visits and not allow other adults to run the show or be in charge. I understand maintaining relationships are important, but I don't believe the most important relationship was the sole focus of this visit being between Taylor and Malaya. It felt like Taylor was more of a buddy and kept giving Malaya whatever she wanted to keep visitation successful. I definitely believe a visit strictly between Taylor and Malaya needs to happen to encourage the relationship and possibly have one or two locations, maybe being the apartment or a park, where there can be one-on-one time between them and establish some form of connectedness to try to keep a routine schedule. So that was her thoughts on that. I guess, well, Mr. Camisa, I'd be interested in your client's view of that visit. If you want to let her talk, or you can talk for her.
I can respond briefly. You know, speaking to Ms. Young, her main focus has always been the child and continues to be the child. She has submitted her fee to the guardian ad litem and is hoping for an independent opinion to remove these supervised visits. As even seen in the declaration, it continues to be tumultuous, the visits. You know, we're on our third or fourth supervisor now. If the current supervisor feels that she's unable to do it, I would just bring up again that Ms. Young's family members are able to do these supervised visits with no issues. If the court is still not inclined to remove the supervised visit requirements altogether.
Thank you. Mr. Miller, any response?
No, I don't got nothing really to say, except for it wouldn't be her family members. I'd want it to be one of those facilities. That's about it.
Ms. Corey?
Hi. So I have spoken with both parents as well as Malaya, and reviewed the records. I am fairly satisfied that the supervised visits probably aren't necessary. The last contact Ms. Taylor had with Mr. Stewart was in February. He has moved on, has a new girlfriend. She has him blocked on social media and also has a restraining order out against him. I would recommend and ask that Ms. Taylor contact the local domestic violence shelter for assistance in creating a safety plan for herself and Malaya. And based on the history of this case, going back to 2016 when it was case in Thurston County. They had a guardian ad litem at that point, and one of the recommendations was that Mr. Miller get a domestic violence evaluation, which I don't believe has happened. I would actually like to see both parties get a domestic violence evaluation and follow any recommendations of that evaluation. And I would prefer that be with Ms. Lovely here in Kelso, if possible. I have received, as Mr. Camisa said, payment from Ms. Young. I have not yet received payment from Mr. Miller.
And I think Mr. Miller indicated he was going to make payment.
Yeah, I'm getting around to it. Okay, so the other thing, actually, I have a domestic violence impact panel already.
What do you mean by that?
I have the certificate for it and everything. I just have to go submit it.
So you've been evaluated already?
Yeah.
Well, provide that to Ms. Corey.
What year was that, Mr. Miller?
In 2017.
What's your thought on that, Ms. Corey?
Well, that's getting on about 6 years old. And also, one second here, I'm sorry. So one of the questions in oh, I'm sorry, I was ahead of myself. Yeah, so was that evaluation done here locally, Mr. Miller?
No.
Where was it done?
Thurston County.
Thurston County. And did it recommend treatment of any sort?
No.
Okay. Yeah, I actually would like to see that. That would be a good start.
All right.
All right. Anybody else want to say anything before I indicate how we're going to move forward?
No.
All right. Thank you, everyone. All right. I want one additional supervised visit, and I want some feedback from it. So I understand what Ms. Corey's saying. There were some issues that caused me concern in the declaration that was recently filed. And I want to do something to just address those. Okay, so let me lay out what I'd like to see. So I'd like the next visit to be on June 17th, which is a Saturday. I'd like it supervised by Cassie Salisbury, who we had agreed to earlier. I would like Taylor Young to attend that visit alone with just Ms. Salisbury. I would like you to meet at GC's truck stop at 10. During this visit, I don't want any other relatives involved. I want it just Taylor and Malaya. And once you get to the truck stop, then my expectation is Taylor would get into the vehicle with Cassie Salisbury, and you will go wherever Taylor would like to go. Taylor, you can plan the whole day. I would like this visit to end at 4 p.m. rather than 6. I'm assuming that that time is going to go well. And then we'll come back here on June 22nd. By that time, the domestic violence evaluation that Mr. Miller had should be reviewed by Ms. Corey. And I'll make decisions regarding any additional domestic violence evaluations. And I'll make a decision regarding unsupervised visits at that time. Okay.
Commissioner?
Go ahead.
This is set for a final review of my report on June 29th. Can we push that out some so that we can take a look at that domestic violence report, see how the visit goes, et cetera? Can we push that out maybe 30 days?
So how come Miss Young isn't taking the domestic violence impact panel?
Well, she might have to.
I mean, yeah, she's got DVs on her record.
Well,
so
I'm gonna address that. The guardian ad litem is recommending that. I'm just not making a decision at this time. Okay, I'm wanting the guardian ad litem to review the material you have, Mr. Miller, and then I'll make a decision.
What happened last time?
Can we push that out to say July 20th?
We can strike the 29th. So first of all, I want to leave June 22nd because we may go to unsupervised visits after that time. And then we'll strike the 29th. And if you want to set that for July 20th, we can do that.
Perfect.
Your Honor.
Yes, Ms. Young.
Respectfully, I was wondering if we could change the supervisor, because on my part, I feel like we've been over this with Cameron's supervisors and they already have their opinion on me from them. And I feel like they're giving false feedback. And I really feel like if it was at my grandparents, I would have one-on-one time. And those in the supervised visits, I really feel should not be there because
your grandparents aren't doing it. Your freaking
Mr. Miller, don't respond. This is directed to me.
And I've been every single time I've been doing it his way since the beginning. I've done everything that he's wanted. And I will do a visit at the place, but the supervisor plays anything, but I really feel like I don't need supervised visits. I can have one-on-one time with my child at my grandparents. And that's a safe, neutral environment for both of us, because I feel Cameron's having people who already have an opinion on me. And
they don't even know you, Taylor.
Point.
Mr. Miller, please.
I'm not gonna wait to talk about this anymore.
All right.
I will do visits at the supervised center though, but I don't feel like his supervisor. I don't want his supervisor because.
So time out. I'm gonna interrupt you. So whoever is talking behind you, Taylor, you need to talk for yourself instead of having somebody whisper into your ear.
Mr. Miller.
We can all hear it.
Your Honor, I just believe that there should not be supervised visits. This has been like a year now, and I feel like I'm not getting anywhere.
Your words or somebody else's words?
The relationship between me and my child, because they're saying whatever they need to say. They have these people coming saying whatever they need to say, because, for example, they said there was a lot of people at the visit. My grandparents, my mom and my aunt and my grandma came to the Children's Museum to watch her play and stuff while I had time with her. I don't see why that was a problem. But if it needs to just be me and her, I can have it just be me and her. But I feel like his supervisors don't need to be there.
They're going to.
All right.
Commissioner?
Yes, go ahead.
I'm so sorry, if I may. I also do have some concerns that the last supervisor was paid by Mr. Miller.
No.
Oh,
I paid for her birthday dinner.
I believe it stated that you gave her $100 for gas and things.
So I'm in trouble because I pay her way to go up there.
Go ahead, Ms. Corey.
That's just a concern that that the supervisor then feels perhaps some
No.
that she owes Mr. Miller something. And I would prefer that this go to a professional supervisor to get that really less biased opinion about the visit, if that's possible, to do just a single visit. I know it does take some time to set up.
Well, that's going to push things out for Ms. Young farther than I think she wants, and probably farther than I want. The last time we were here, we agreed that Cassie Salisbury could be the supervisor. That got changed. Honestly, the Chandra Muncie declaration, I thought was a very factual declaration, and I didn't see that it was, I didn't read into it that it was biased one way or the other.
But I had 100% one-on-one contact with her. There was no me separating from her or me being her pal. And she stated that I gave her whatever she wanted. I got her ice cream and lunch. She's my kid, and I haven't seen her in a month and a half. I don't see whatever I spend my money on my kid or what she wants, that has to do with me. And I don't understand what she was meaning. I gave her whatever she wanted to make her. They're sitting here making it seem like I don't have a relationship with my kid, that I don't do this, and that is not the fact. Every single time I ask her what she wants to do, we hang out all day, and it's uncomfortable when someone's following me to the bathroom, when someone's 2 centimeters away from me, saying, I need to be in ear range and know everything. You don't need to follow me to the bathroom. That's what you don't need to do. You're taking this too far. And it's getting ridiculous, because it's getting to the point where they're forgetting that I am her mother at the end of the day. I would do anything for her. And these supervised visits is just crazy, because Cameron has a whole list of things he has done and put me through and all this, and everyone's just bypassing it like he's this #1 dad of the year. And he's not.
No, we're not, Taylor. Okay. And everything that is going on, you've done to yourself, to take accountability for that.
Mr. Miller, just let Ms. Taylor speak.
I just really believe if I have to do visits, that they should be at my grandparents unsupervised. It would just be me and her, and that is a mutual play for all of us. And he knows that.
I'm not going to change my decision. I want to get feedback from one additional supervised visit, see how it goes.
And are these the same people who wrote statements about me and declarations? Because I'm pretty sure she wrote a statement as well.
Well.
And like he said, they don't even know me.
Well, again, we had discussed Cassie Salisbury a couple weeks ago. She was acceptable then. And we're probably moving to get to unsupervised visits. I just want one more supervised visit with just you and Malaya. And I want that to occur on June 17th. And hopefully that will go great. And then we can discuss what we do going forward on the 22nd. So I'm not changing my decision on that. 17th at GC's truck stop from 10 to 4. Okay. All right. Thank you. We'll see you back here on the 22nd. Miss Young was here. There we are. Miss Young, there we go. Okay. So I read the declaration, and it looked like the visit went pretty well last weekend. Miss Young, what was your impression?
It was nice. We went to the movie, and I got some one-on-one time with her. We went to the park, and again, it was good. feel like we could still do the same thing, just us. It went well. It was definitely, she was nice.
All right. Mr. Miller, any comments?
Yeah, actually I do. So
Okay.
I've been under the impression from like my girlfriend and Taylor and my girlfriend have been talking that Taylor wants to just settle this. She wants to just get along with the parenting plan. That's my impression. Yeah, I'm under the impression that Taylor was going to bring it up in court today, but I just beat her to the punch, I think.
What's your position on that?
Mine is
No, I'm talking to Mr. Miller right now.
Okay.
What do you mean? Like,
I mean,
like, how do I think on that?
Well, there's a temporary parenting plan that calls for unsupervised visits basically every other weekend. That's an order that was in effect until we changed it, because I think it was Drew Stewart came into the picture and he had some issues, and we wanted to make sure that your daughter wasn't in contact with him.
Yeah.
My understanding, he's out of the picture at this time.
Completely.
So, what's your position on unsupervised visits every other weekend, Mr. Miller?
I don't have an issue with it.
Okay. All right. Ms. Young, what's your position on that?
But time out, please. I do want to like make it clear though, we're all on the same page that my daughter comes home. That's all I ask. That she comes home, she's back here for school. That's it.
And I proposed something else too, but you guys haven't responded to it. And I'm waiting for my attorney as well.
So tell me what's your position on the if we re-implemented the current temporary parenting plan?
Well, he wanted to be every other weekend during the summer, every other week during the summer, and every other weekend during the school year. But I wanted it to be, we just switch it. I get her for the whole summer. He gets her every other weekend. And then I get her on the weekends during the school year. I feel like that's the only way fair. If not, I feel like she belongs to be with me 5 days a week, because this every other weekend, I don't feel like that's another 2 weeks going without seeing her. So I said, if you guys really don't want to move her in school, then she lives with me for the breaks and for the entire summer. That's 3 months out of the year that she can live with me.
I can't allow Malaya to go all summer.
Mr. Miller, let's just listen.
Okay.
Right now.
And she would still get every other weekend. That'd be the same thing as 9 months of the year when she's in school, that I'd have to see her every other weekend. So why can't I have her during the summer? Because the big thing was that she's in school. Well, when she's not in school, she should be able to be with me. I've had her for 5 years of her life. This just started. And the only reason she hasn't been with me is because Cameron was keeping her from me.
We're not going to go down that road, because that's not what we're even talking about. We're not going tit for tat. We're trying to settle it, Taylor.
I'm not going tit for tat at all. I'm just stating that if you want her for the school year, I feel like I should get her for the summer.
Okay, I need both of you to listen now. I'm going to ask Ms. Corey to weigh in on this.
I don't think we're near finding a final solution. I think going back to the previous temporary parenting plan is a good call. And obviously this investigation needs to be completed before we can find some common ground. As of yet, Mr. Miller has actually, we have had a Zoom appointment, and that's all. I have not received payment from him as of yet, going on a couple of months now. So, but
I'm not making no payment until everything's done. That's how I work. When the job's completed, that's when I pay. It's no different than running a business. When the job's completed is when payment is received.
The problem with that is if you don't like the conclusion at the end of the job, then you can walk away and not pay. And that leaves guardian ad litems vulnerable. So they need to be paid as we go along.
Well, if me and Taylor figure it out, then she was actually brought in for no reason.
Obviously, we didn't figure it out.
Well, we haven't even really talked about it yet, Taylor, have we?
All right. No speaking right now. I want to find just a moment here. All right. I encourage the parties to reach a resolution, but for right now, I'm looking at the temporary parenting plan, and it calls for every other weekend from Friday at 6 to Sunday at 6. And it calls for the drop off and pickup location at GC's truck stop. And what I want to do is,
can we move it a little closer? Because I drive like almost an hour and they drive 15 minutes.
Not 15 minutes to GC's truck stop.
Here's what I'm looking at is, rather than make changes, what I want to do is implement what the court already decided. And then I'm going to tell you what the potential next step is, okay? So Ms. Young saw Malaya on the 17th. If we go every other weekend, that means it's July 1st or June 30th, and July 1st and 2nd would be the next weekend.
I talked them, I do have a family reunion from the 27th to the 3rd that I wanted to take her to.
Well, you'll have her there part of that time.
Because it's in Spokane. But I'd love her to meet that side of the family.
Again, right now, I'm going to stick with the temporary parenting plan that was in effect, that was entered on September 22nd, 2022. So it's going to be Friday at 6 to Sunday at 6. If you and Mr. Miller can come to an agreement as to what would be a final parenting plan, then I encourage you to do that. Otherwise, I think your next step is to set this for a trial regarding a permanent parenting plan. And you would have to put that on what's called the Universal Trial Setting Calendar, which is on Wednesday at 1 p.m. And then if you can't come to an agreement, you can each present your case as to what parenting plan should be. That's at that time, Ms. Young, you can explain to the court that you'd like Malaya all summer, if she's going to stay with Mr. Miller all winter or all school year. So that's where you would make that argument. Okay.
Your Honor, if I was to accept like her offer for her having Malaya all summer, would I not see Malaya at all summer?
I think it would essentially switch. You would have to see her every other weekend.
Okay.
But
so
then we
during the
communicate.
What I hear her saying is during the school year, she would get every other weekend. During the summer, you would get every other weekend.
Okay.
That would be the proposal.
And then we have breaks. We split them like Christmas. We split them.
Sure, you'd have to figure out spring break, Christmas break, and other holidays, how you're going to handle that. You'd have to handle, you know, if Mr. Miller wanted to spend a week on a vacation with Malaya during the summer, you might have to factor that in.
Okay.
So at this point, I'm implementing the temporary parenting plan, unsupervised visits, Friday at 6 to Sunday at 6. And I encourage you to work together if you can and come up with a plan going forward. You can both sign off on it and send it to me and I'll sign off on it. Or
is the training order listed to where I can actually talk to her, or do I still only have scheduled visits?
Let me see if there's a note here about that. Do you have any objection to a telephone call, Mr. Miller?
No, Your Honor.
Okay. Let's limit it to once a week. So that would be 2 calls in between your visits for right now. And then again, you and Mr. Miller can speak and I hope you come up with an agreement. Okay.
Yes, Your Honor.
Ms. Corey, anything you'd like to add?
It seems like my services aren't wanted in this case. May I be excused?
Yes, at this point you can. Mr. Miller, you're still required to pay Ms. Corey for the time that she put in.
If she don't mind.
What's that?
I still want her in it. My attorney hasn't responded to me or anything. I have no idea what's going on.
All right. I don't know that I was going to set another review hearing here because I think either you're going to come to an agreement or you need to set it for a trial.
But if Twyla doesn't mind, I'd still like to have a conversation with her.
Ms. Corey?
I don't mind staying on the case, but I would like to be paid for my time. Yeah. And the court's policy, as well as my policy, is that I be paid ahead of time, and I hold that money. If there is any left over after completing the job, then that would be refunded to Mr. Miller.
Okay.
To Miller or me? Because since Miller didn't pay.
To both.
Oh, okay.
All right, I'll set a review. I'm going to set this out a ways. I'll set a review for July 27th. And that will be to look at the status of payment. The court has the ability of entering a judgment against one party or the other if there's no payment. And I may consider that at that time.
Yep.
Okay.
What was the review date again? I'm sorry.
You bet. July 27th. That's a Thursday at 9 o'clock.
Okay.
Okay. I hope you can come to an agreement. Okay. Thank you.
Next, we have Next, I have Cameron Miller and Taylor Young. This is cause number 22300369008. I have Ms. Corey. Do I have Cameron Miller or Taylor Young? All right. So Ms. Corey, this matter had come before the court on an issue of fees and review. Why don't you give me an update on what's happening?
Well, I'm about 10 hours in and have not yet received payment from Mr. Miller. I have received payment from Ms. Young. They indicated to me recently that they have come to an agreement on the parenting plan. And I'm just wondering what to do now. I have one small issue with their parenting plan that hopefully can be worked out between them. But I don't know what to do. I need the court's input here.
Fair enough. So let's do this because it sounds like there's a potential agreement. Mm-hmm. Why don't we put the matter over, because it's already set for review. Why don't we put it out 3 more weeks to August 17th? That gives you an opportunity to see if they can resolve that issue, have a proposed order, and ideally appear on the docket. We can address the order if there's an agreement, and we can also address payment. And I would be clear to Mr. Miller that he is obligated to pay your fee, and the court can consider a judgment or other relief potentially if he fails to pay that.
Okay.
All right. So over to the 17th, and hopefully fees are paid and we have an agreed order by that time.
Thank you.
Thank you. All right. Next, I have the Miller and Young matter. This is 22300369008. There we are. All right, and I have Ms. Corey, this matter on to review payment status.
I have had a really difficult time getting in touch with both parties. They apparently have come to an agreement and have not yet filed that with the court. And Mr. Miller has not yet paid me.
Okay. So one party is paid, but not the other. Is that fair?
Yes, Ms. Young gave me a retainer of $1,600. At this point, I am, if the invoice I have has about 10 and a half hours on it for $1,575. So if Mr. Miller were to pay me the $787.50, half of the $1,575, I could refund some of that to Ms. Young. But
here's what I'm going to do. At this point, I'm going to go ahead and release you from service on this case. If the parties don't want, the parties are not motivated to continue with your services, I don't want you to have to keep showing up to hearings like this and sort of spinning your wheels. So I authorize you to go ahead and just not issue a final report, but just issue essentially a non-compliance, that the parties aren't complying with you, that this is your final invoice, and that the court authorizes that you to pay yourself out of what's been paid so far. And if the parties have disputes about who should have paid what, they'll need to bring that back to the court.
Okay.
That sort of puts the ball back in their court.
Okay. So is that a actual document I need to file?
My preference would be that you treat it like a GAL report, as far as the caption and the but essentially a cover sheet. And you can even just do it as a letter. That way, if it's a different judicial officer, they'll understand what happened. So okay. Just that the court's authorized you to withdraw, this is the invoice at this point, and that if there's any disputes, we're getting payment, and then the parties will need to bring that back before the court.
Okay, thank you.
All right, thank you for being here.